Time?
3 minutes is what I'm
3
counting.
minutes, you got it.
Yeah.
Ready? All
Yep.
right, let's begin.
May it please the court. My name is Ezekiel Lugo, and I represent Appellants Mid-America Apartment Communities, Inc. and Robin Jimenez. And I will be referring to them as the appellant or the landlord. At this time, like I noted, I would like to reserve 3 minutes for reversal. Our position this morning is that the trial court erred when it denied the motion to compel arbitration for two main reasons. First, that the plain language of the arbitration provision applied to the claim asserted. And second, that the claim raised issues that required reference to or construction of the lease agreement. There were some additional issues regarding unconscionability and waiver that were raised in the trial court and addressed in the initial brief, but because those were not asserted in the answer brief, I will just rely on the arguments, the written arguments for those points. We respectfully request that the court reverse and remand with directions to compel arbitration. Turning to the first point, the plain language of the arbitration provision in this case applied to the claim asserted by the plaintiff.
Now you had Judge Bauman, correct?
Correct.
He's a seasoned trial judge. He asked both sides several times, do you have any controlling case law on point? And I think both sides said, not really on point, but I have some nursing home cases. Is that true or false?
I think that was the position to Judge Bauman, Your Honor, and
Well, the reason I'm asking is the nursing home cases were distinguished because they involved continuity of medical care that resulted in injury outside during, I think, the transport process. Here, no one really had a case on point. And I think the appellee argued something to the effect that, well, Judge Huey and other trial judges in Hillsborough have affirmed rulings saying you don't get arbitration under these circumstances. Were any of those cases appealed, and if so, what was the result?
Your Honor, the issue has been bubbling up in the trial courts in the context of a landlord-tenant case, and that is this case is one of first impression in that context. Now, the analysis from the nursing home cases would apply here because it's a motion to compel appraisal. So there were several trial court rulings that have been made where these sorts of provisions have been enforced. To my knowledge, one of these cases was appealed out of Orlando, but that appeal ended up in a settlement, and there was no decision issued
There's
from
nothing binding anywhere, is what you're saying.
directly to the facts of the case, no, Your Honor. But the analysis from Seifert and the progeny from Seifert applies.
Well, I mean, it seems to me that the judge is entitled to look at the context and the facts. And the judge in this case said, hey, wait a second. It's easy to just say all claims and disputes between the parties go to binding arbitration. But if you dig a little bit deeper, it's in the context of the lease. If the lease was signed with the understanding that it would apply to injuries on the premises and not in the common areas, then that's what it seems to me that's what the judge did. Said, hey, this is a common area injury. Could have happened to anybody. You don't need to be a resident to be walking on the premises. A third party could have been injured that's not a resident. This person happened to be a resident. I mean, the judge made a judgment call, the way I look at it, and pretty astute judge in question. So explain to me how this judge got it wrong.
Well, first of all, Your Honor, the standard of review in this case is not abuse of discretion. It is de novo.
Well, that's true, but also as a former trial judge, the judge's decision comes clothed with a presumption of correctness. So you got to overcome that.
Right, Your Honor. So the error as to so there's two parts to the analysis. One is the language of the arbitration provision itself, and whether that is a narrow provision or a broad provision under Seifert.
I'm sorry to interrupt you, but I think you're about to focus on what I've been waiting to ask you about, which is one view of this is that the Fourth District's opinion in the Lennar case should control. And the question becomes how to distinguish the significant relationship cases. And I think what you've argued, and I just want to make sure I understand, is that the significant relationship test, which is the sort of view the context analysis. Am I right so far?
our position is that it's a two-part analysis. First, the plain language of the.
Okay, we've skipped over the
provision.
plain language and now we're on significant relationships.
Right. So
Is-
if the plain language doesn't clearly include the particular provision or claim at issue.
Or
then-
if the plain language says relating to, arising out of,
Right.
which this one does not.
It does, Your Honor. And the definition of claim on page 42. So there's two parts. There's the arbitration provision saying all claims arising between the landlord or the tenant will be resolved through arbitration. That's on page 42 of the appendix. The term claims is defined in the contract, also on page 42. And that definition is broad and it includes the language arising from.
But I'm not sure
relating to.
that helps you on distinguishing Deweese, because the way I read the Fourth District's resolution of that case with the Lennar case is in the operative phrase of the arbitration agreement, if your arbitration agreement says something like any and all claims arising out of or relating to this contract shall be subject to arbitration, you have what's called a broad clause under Jackson and Shakespeare. And then if you have that, if you have a broad clause, then you have to do the significant relationship analysis. Am I
Correct. And that's our
following?
position. Yeah.
And your argument, as I understood it, was we don't have to do significant relationship because the provision here doesn't require that analysis under the reasoning of Seifert, Shakespeare, et cetera, and best applied most recently in the Lennar case. Have I
Right,
missed
Your Honor.
something?
No. In the Lennar case, the Fourth District analyzed the language of the arbitration provision and said the claim falls within that language. We don't need to go any further. But our position is, even if the court thinks it needs to go further, we satisfy the significant relationships test. And going back to Judge Volante's question.
How was that satisfied? You said you satisfied that? Tell me how, please.
Yeah, Your Honor. So the definition of claim in this case talks broadly about any claim, dispute, action, proceeding, cause of action, whether arising in tort, including personal injury, for damages, whether arising under the common, statutory, or other law.
It doesn't say location. The location is important.
And
I think
I'm
that's what threw Judge Bauman against your
Right.
argument.
And I'm getting to that, Your Honor. So
Okay.
it defines that broad spectrum, right, of the type of claim, whether common law, tort, personal injury. And then it says, between you and the landlord arising from or relating to, and it talks about certain places, the property, which is defined on the first page of the arbitration agreement as the entire apartment complex. Then it also talks about use of your apartment and or common areas. The particular claim asserted here is that this tenant was walking in a common area when she tripped and fell over an exposed utility box cover, I believe. So her claim is arising from or relating to use of the common areas. It's clearly within the language, the definition of claim under the arbitration section of this agreement. Now, we meet the significant relationships test because in the context of this claim, there's going to have to be reference to or construction of the lease agreement to decide issues that are raised by this claim. Issues including the particular duty that's owed. And Judge Volante, you mentioned that the duty in this case will be the same duty that will be owed to any third party that's on this apartment complex, and that is not correct. In the landlord-tenant context, the common law that developed through many decades has been affected by the Residential Landlord-Tenant Act. It has displaced both the common law and the statutory law that apply to the relationship between a landlord and a tenant. And that's important because the legislature in the Residential Landlord-Tenant Act said that the duty to maintain the common areas is on the landlord unless otherwise agreed to in writing by.
Well, let me ask you one more question. Didn't the judge make a ruling in effect that this was an ambiguous contract and should be construed against the draftsman? So he construed it saying, hey, it's talking about the premises in general, which is where this lady lived, not where she happened to walk outside. Because It seems to me that if you put it in context of the premises rented, that's not an unreasonable ruling.
Respectfully, Your Honor,
I know you disagree, but
with
that's
that
fine.
characterization of the record, I don't think Judge Bauman found this to be ambiguous. What he said is that he did not think the parties had contemplated that the arbitration clause would extend to this sort of claim. Our response to that finding by the judge is that, well, he did not look at the plain language of the definition of claim, which broadly includes tort claims for personal injury for damages under the common law or statutory law. So that's why we believe that part of his ruling was incorrect. To the extent he relied on significant relationship cases to find that there was no significant relationship in this particular context, our position is that he erred, because in this case, this claim is going to raise issues that require reference to the contract. To decide the particular duty that's owed in this case, reference to that contract is required, because the Residential Landlord-Tenant Act has displaced the common law in effect. And even if that act was not enacted and we're looking at the common law as to the duty that applies between a landlord and a tenant is important, because it also requires reference to the lease to decide whether the tenant at the time of the injury was either an invitee.
Let me ask you a question. Does it
or a
change
licensee.
anything? Does it change anything that, and I'll ask your opponent this as well. Does it change anything from your perspective that the definition of claim says it refers to claims whether now existing before the lease was written or arising in the future that arise from your use of the apartment and or common areas? And what I'm focused on there is the fact that the tenant could opt out of this arbitration clause, right? There was a procedure
Correct.
specified for that. And this document, which included the arbitration provision that she's charged with reading, provides that she's agreeing to submit claims that may exist even before the lease was executed of this specific nature, personal injury claims. Now, I know that's not what happened, but what does that tell us about what the parties intended concerning this arbitration clause?
That it was that the intent was to broadly include any and all claims related to use of the apartment and or the common areas. Now, I sense some concern, Judge LaBrid, on your part about whether this might have rendered the agreement unconscionable. And that argument was not made.
I'm not concerned about unconscionability at
so,
least for purposes of this discussion.
Yeah. So unconscionability is not an issue, at least as to that.
Well, you did
point.
you did make another argument towards the very end about inconsistent results. Is that still on the table, or are you withdrawing that argument? In other words, if you don't have arbitration, you could get a verdict against a third party if they were sued separately, the power company, let's say, or the gentleman who disappeared to another country somewhere.
I don't recall making that argument, Your Honor. My position is that the duty that applies is different between.
Maybe I was making it for you in my head, but I read that somewhere. But let's move on. I don't want to confuse you.
So the duty is different. The point I do want to make, and that we did make in the briefs, is that the duty owed to a third party would be, the analysis as to the duty that's owed to a third party would be different from the analysis that would be owed by a landlord to a tenant, which requires reference to the lease agreement to decide if the tenant, for example, was in an area in which the tenant was allowed to be, if the tenant was in an area that's outside the terms of the lease, or if the tenant was in an area where he or she was allowed to be, but was engaged in a non-permitted use, which is relevant because there's case law talking about that, somebody that's an invitee when they first enter the premises, that status may change depending on the actions of the person at the time of the injuries. In this case, the answer brief raised the argument that, well, the arbitration would only be limited to the particular use that was being made of the premises.
You're down to 5.5 minutes. You said you want to reserve 3, right?
Yes, yes. So we disagree with that position, but the use of the premises is relevant. There's a provision saying that the common area should be used only for ingress and egress. Particular uses prohibited smoking, gathering. If the tenant in this case was engaged in any of those issues or any of those uses, arguably the status may not be that of an invitee. And that's an issue that would be raised by the claim that's been asserted in this case. That's going to require reference to the lease agreement. And that is why we believe, for those reasons, because of the duty issue, the potential use, and the status between the status of the tenant at the time of the injury requires reference to the lease agreement to decide those issues in the context of the claim asserted by the tenant in this case. And Judge Valenti, at some point, you mentioned that either Judge Bauman or the case law required that the lease agreement, that he found that it was ambiguous and that required that it be interpreted
Well,
again.
the argument was made somewhere in the brief, but
Yeah, so we disagree with that position. The more recent case law, Jackson Forward, it's clear that the interpretation of the language of the arbitration provision should be given a broad interpretation, and doubt should be resolved in favor of arbitration. This is not a situation where the contract has to be construed against the landlord necessarily. And this court mentioned that in the interpretation of the arbitration clauses should be read in the context of the entire agreement, giving effect to all provisions and resolving ambiguities in favor of arbitration. This court noted that in the Osprey case at 329 Southern 3rd, 177 back in 2021.
if you stop now, you have a full 3 minutes. You want to do that?
I will do that, Your Honor.
Okay, you
thank
got
you.
it.
May it please the court, Benjamin Stevenson on behalf of Alexandria Gonzalez. I have a short opening argument. In her complaint, Gonzalez asserts she was a public invitee, and Mid-America breached its common law duty to public invitees to maintain the common area in a reasonably safe condition. Mid-America wants to replead the complaint so that Gonzalez is not a public invitee, but a tenant, asserting a contractual, statutory, or some other claim. It can't do that. As pled, Gonzalez's claim is not arbitrable because it does not emanate from a unique contractual duty. Her public invitee claim requires no reference to the lease, and any third party could.
Well, let me just ask you a question, because that's a very cogent argument, but is that an admission that had she pled she was a tenant, all those definitions would say, hey, you have to arbitrate this claim because you were injured in a common place, which is incorporated into the residency?
I would draw a distinction here. There's a distinction between the tenant's rights of access and a public's rights of access. I am not familiar with any circumstance in which the tenant has fewer rights of access than the general public, but oftentimes they have more. And so if their right of access turns on their status as a tenant, then obviously they're going to have to make that claim. But if the tenant, just like anyone else, is walking in a common area that's open to the public, they're a public invitee, and they do not have to bring a contractual breach claim. They don't have to bring a statutory
Mr. Stevenson, I'm just looking at the allegations of the complaint, and I'm specifically looking at paragraph 10, where she alleges that she was properly and lawfully on the premises as a customer and business invitee. Is it completely absurd to read into customer the inclusion of a tenant who is a customer by way of being a tenant of this landlord?
I don't think that's a fair reading of the complaint. Customer.
I didn't think you would, but I felt compelled to ask you.
Sure. No, that is a standard language in a complaint against the business that is held open to the public.
So let me ask you, just shift your attention a little bit. Is the arbitration clause in the lease ambiguous?
We do
You
not.
taken that position?
No, we do not. We think it's unambiguous.
And your opponent agrees, and none of us can find alternate meanings to thou shalt arbitrate most everything, at least, if not everything. So the
Yeah.
definition of ambiguity is it's capable of two reasonable interpretations. You're agreeing that it's only capable of one because it's not ambiguous. And so I think your case rises and falls, doesn't it, on the significant relationship analysis?
It does not. So we confront both issues, and if I could give an opportunity, I would like to walk through this. I think the first question is, my friend on the other side keeps on trying to characterize the arbitration provision as broad. And broad language in an arbitration provision usually, almost always, is subject to a significant relationship test. That's what Jackson holds. On the one hand, they want to say it's broad, but then they want to say, well, it's obviously included. Now, so the question is, when you look at Lanier Homes, what did they mean by expressly included? I would submit it's something more than simply being included.
Well, and that's why I asked the question about the temporal specification in the definition of claim. And specifically, what I was asking about is the bargaining away of the right to litigate in a trial court, even a claim that existed before the lease was executed.
Yes.
And that would seem to be all-encompassing of any claim this woman might have or develop during the term of this lease. And perhaps at its expiration, but at least for our immediate purposes.
Right. I'm not sure.
And reading the thing in in its full context and giving meaning to all of its provisions, that the intent that was expressed is broad. Now, I understand your characterization of your opponent's position on this, because it has a little bit of, it starts out with all claims that arise between you and landlord, and then the definition of claim sort of incorporates this arising out or relating to. I get where some of the confusion might be coming from, but fundamentally, what is if your best case isn't significant relationships, and assume for a minute that we don't agree that the complaint is as narrow as you would have it be, then what's your best case?
Right. Let me finish up with a significant relationship, because I think to me that there isn't much argument on the other side. And the way I see it, and the reason I say that is that has the significant relationship test is looking for a unique duty that arises from the contract, the agreement. And that is usually the two features, the two salient features of a unique duty are that third parties can't bring this claim, and you have to refer to the agreement to bring the claim. And neither case is here. Let me turn back to whether the subject matter of the arbitration.
And before you do, I just want to, today is arbitration day, so I've been thinking about it a lot. You're not the only arbitration case on the docket, but let me make sure, just to begin with the basic. What this judge was tasked with doing at the motion to compel arbitration stage was determining whether there was a valid agreement to arbitrate. Am I right?
Yes.
And nothing else, because everything after that is for the arbitrator.
Right.
I think we can agree on that. So in the court, so what the trial judge has a pretty narrow focus, which is there an agreement to arbitrate? And of course, that takes into account what is the subject matter of the claim. So I just wanted to preface that, though, with keep it simple on what the trial, I think that going into a bunch of alternate theories of liability and what has to be proven is not necessarily helpful.
Yeah, I'm not sure I'm going there, but thank you for
Okay.
the suggestion. I think the first thing to say is that unlike the fourth DCA, this court nor the Supreme Court has specifically held that an arbitration that claims expressly the subject for arbitration must still, whether they must still also bear a significant relationship to the contract.
So are you kind of conceding that if we would follow the fourth decision in Lennar, and perhaps you can tell me in a minute why we shouldn't, but if we were to find that controlling, do you believe that we would need to certify a conflict with something, or are you conceding that the case is controlling? Wait, tell me where you're coming from on the Lennar
I'm not sure
case.
I'm not urging a certified conflict on the issue. If that is where the court is going, I would strongly urge the court to exercise some caution in this regard. And the reason,
My question, maybe I overcomplicated it. My question is, why I get at bottom is, why isn't the fourth decision? I'm sure you're gonna tell me why Deweese is controlling and help me understand how to reconcile those two cases. But fundamentally, one of the questions I had for you before we even got here was, why isn't the opinion in the Lennar case controlling the fourth district's opinion? And I agree with you. I don't think it's in conflict with anything, and the Supreme Court hasn't passed on this precise issue. So either it's controlling and we adopt it because we have a choice to either go into conflict with it or not. And maybe that's what I should have asked you, is if we rule in your favor, do we need to certify a conflict with Walensky?
I don't believe you do. No.
Okay, tell me why not.
I don't think it's binding upon you, but I also don't
It's
think
not binding on us. We can definitely go into conflict on it.
Right. But I don't think you need to even address the issue. And the reason why is that this claim that was alleged in the complaint was not expressly included in the arbitration provision.
And you think it was in Lennar?
It was in Lennar. It's not here.
Okay.
And if I could walk that through on why that is the case. As you recognized, there's a difference between the type of claim and the subject matter of the claim. The type of claim, of course, includes personal injury and torts, just like it did in Lennar, just like it did in Deweese. But the meat of it is, well, what's the subject matter of the dispute? And here it's limited, but it's limited to broad ideas: the contract, the agreement, the property, the use of the common areas. And I think a comparison between Deweese and Lennar Home really explains what the difference is between expressly including a specific claim and not. I will note that the facts are very similar in Deweese and Lennar Home, but they came out differently. So you got a homeowner who sued the developer for personal injury after she fell on a bike in the property development's roadway. And so that is similar. It's also similar that both arbitration provisions in both cases, like in ours, included personal injury and torts. Where's the difference? And the difference explains why the outcome was different. The difference was the subject matter of the arbitrable disputes. In Deweese, it was any action or inaction of the parties to the claim. That is excessive. That's broad. And that, you might argue, is expressly covering the precise claim alleged in the complaint. But I think that neuters the word expressly. Expressly must do something more than simply include it among the subject matters for arbitration. Otherwise, everything is expressly included so long as it falls within this broad category. So then look at Lennar Homes. Instead of having a subject matter limited to any actions or inactions of the parties, in Lennar Homes, the subject matter, and not the type of claim, the subject matter, what occurs after the relating to phrase, is personal injury sustained in the community. That expressly included the claim at issue. That was the claim at issue. And thus, it was not, the fourth DCA did not subject it to the significant relationship test. That's the delta between the two cases. One, you have a broad provision. One, you have a very narrow provision that essentially identifies on all fours what the claim is that is being asserted. Here, the arbitration clause specified the subject for arbitration in broad terms.
Well, wait. Let me ask you a question. I was just looking at the language at issue in the Lennar case, and I believe what it says is that, bear with me, it says that claims shall include but not be limited to claims arising under related blah, 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 arising under or related to the community or any dealings with buyer and seller. And how is that really different in practical terms from claims arising out of your use of the common areas? I mean, we're talking about an apartment building versus a homeowner community. In the Lennar case, the person was riding their bicycle on what amounts to a common element of the HOA. Here we have a tenant who lives in the building and is injured working through the common areas. I don't see a huge difference there.
I would point the court to subsection 3 of that arbitration provision. That's a little further down. That is on all fours with their claim. It was relating to personal injury or property damage alleged to have been sustained by the buyer, buyer's children, or another occupant of the property, or in the community. Personal injury sustained in the community. That is specific. That is what we're looking for. That level of detail is what we're looking for when we want to say the claim was expressly included. Without that level of detail, you're back to DeWise. There's no question that one of the parties was one of the actions or inactions of the parties was clearly a fault, clearly the cause in DeWise, but that did not make it express. Express is identifying the claim at issue. And so here we have an arbitration provision that is in broad terms, right? It refers to the lease, the apartment, the property, the use of the common areas. And this is broad like DeWise. And because the subjects are broad, they must have a significant relationship. That's the teaching of DeWise. That's the teaching of Jackson. The provision here is a far cry from the specificity that the 4th DCA found were specificity required to expressly include a claim in the arbitration. Lennar Homes, again, it was personal in the subject matter of the dispute was if it included personal injury sustained in the community. That's exactly what happened. And so for that reason, I think that Mid-America gets it, in fact, backwards, right? It argues that the arbitrable subject matters here are broad. That's in the reply, and that's what you've heard today. And thus, the provision expressly includes Gonzalez's claim. But that can't be the case because broad, although a claim following under a broad announcement of the subject matters for the dispute for arbitration require a significant relationship. You get it backwards. Maybe it'd be helpful to switch to, the question may hang on the question of what does use in the common area mean? Uses of a common area. And I think on this point, people would not naturally say that tripping over a utility box is a use of the common area.
Well, you're walking in the common area and the utility box is, then you get into the whole merits of the premises liability analysis. But certainly somebody who lives in an apartment building is going to have to use the common areas regularly to navigate between their unit, the swimming pool, the parking lot, whatever.
But they most certainly use it to walk. They don't use it to have a tort, fallen upon them. No one would say, well,
so if she drowned in the swimming pool, that would be okay, but walking isn't?
I think they're different. And I think what that does is, since the language is unnatural, to say that tripping over a utility box is a use of the common room or common area, We look to the lease as a whole. That's another canon of interpretation that always comes before a ruling of, well, we can't figure it out of ambiguity. And so when we look to the lease as a whole, we see that section 34 discusses uses of the common areas.
Mr.
Naturally,
Stevens, I apologize for interrupting, but you've got 2 minutes left.
Thank you. Naturally, that is what is the use of the common room is referring, or common areas is referring to. What's outlined later as here are the uses that you can put the common area to. Section 34. It's 3 pages long. This is the point, though, is none covers Gonzalez's claim. This is not a dispute about smoking in the hallway. Yeah, I think the last thing. Ultimately, because the claim at issue was not expressly included in the arbitration provision, because use of something does not entail tripping in a common area. Because Lennar Homes and DeWeese were focused specifically on what explained what it meant to have a expressly identified dispute. And that is not what we have here when the arbitration provision has broad language. Ultimately, then we are now with, because there's a broad language, there has to be a nexus to the agreement. And the agreement, the 2 features, the salient features for a nexus are that you have to refer to the contract, and a third party couldn't bring the identical claims, but neither is true here. A third party could bring the identical claims without any reference to the contract. So that nexus is missing here. Without an express claim,
20
without a nexus,
seconds. 20 seconds to wrap it up. Your time is almost up.
without a claim, without a nexus, we urge this court to affirm the trial court below.
All right, thank you. Mr. Lugo, you've got 3 minutes reserved.
Thank you, Your Honor. Now, first off, a point of clarification. In this case, the issues being decided by the trial judge were threefold. Number one, whether there was a valid agreement to arbitrate. Number two, whether an arbitrable issue existed. And number three, whether the right to arbitration was waived. So all 3 prongs were placed before the judge. If the court looks at appendix pages 21, 22 on the motion, those 3 issues were raised. They were briefed by both parties. The judge ended up ruling ultimately on the fact that he believed there was no arbitrable issue in this context, and the argument on appeal has focused on.
How important is the allegation in the complaint that she was injured as a business invitee and customer of the apartment complex?
Your Honor, it brings the whole fact of relationship between these 2 parties to the fore of the case. So the allegation in the complaint also is that the landlord was operating an apartment complex. And that's a paragraph
And under
4 and 7.
Under your opponent's theory, a plaintiff who's bound by this lease could always avoid arbitration by not attaching the lease or referencing the landlord-tenant relationship. Does that make sense?
No, it doesn't make sense, Your Honor. They can't just avoid the arbitration clause by creatively pleading out of the arbitration clause. The entire circumstances of the case matter. My opponent has argued that arbitration is not proper whenever there is a claim that could be asserted by a third party. That is just simply not true. In Jackson, the claim at issue was a fraud claim that could be asserted by any party against the defendant. In the Phillips case that this court decided in 2022, Phillips versus Lyons at 341 Southern 3rd 1171, it was a civil rights action where they were alleging that the developer was discriminating against the plaintiffs because they were a mixed race couple. This court said, well, to decide that civil rights claim that could be brought by any party, there has to be reference to the agreement to decide if it was really racial animus or some delay caused by what the parties are supposed to do under the contract. So that argument by my opponent is just not correct. And turning to the point of whether the court should certify conflict if they agree with my opponent, the Lennar case pointed out that DeWeese ended up with the holding that it had because the language was broad and because it was ambiguous. neither party in this case is arguing that the language of the provision here is ambiguous. So if
Is it your position, let me just be clear. Is it your position that we should and can follow the holding in Lennar and that that's dispositive of this case?
yes, Your Honor, the language specifically references not just the general tort claims, but those arising from or relating to the property. Remember, they're alleging a dangerous condition on the property, as well as use of your apartment and or the common areas. She was
Mr.
in here
Lugo, I don't want to
allegedly-
interrupt you, but your
Hold
time
on.
has expired. Did you finish answering the judge's question?
Yes, Your Honor. We just
right.
respectfully request the court
All right,
reverse.
well, thank you both. That was a tough case to argue. You both did a great job. I appreciate it.
Thank you, Your Honor.
We're gonna move on to the next case now. If everyone's ready, that's gonna be the MHC Holdings versus Physician Partners LLC.